Yeah, please, my Lordship.
Yes.
Lordship, I'd like to mention item number 4. With the consent of both parties, I'd like kindly fix it on after 1 week.
After 1 week.
Yes, Lordship.
Third Learned Counsel, Mr. Such and Such, appearing for petitioner.
Respondent number 1.
Appearing for the respondent number 1, who prays for listing the matter after 1 week with the consent of the other side. So, list after 1 week. Yes.
Mr. Lordship, I beg to mention item number 3.
3.
Yes, Your Lordship.
Yes.
The leading counsel is indisposed. I pray that this matter may be fixed on Friday, 13th of February.
Friday, next Friday.
Yes, coming Friday.
Either Thursday or next week, the week after that. Friday, I don't want to keep many matters.
The next week then.
I'll say after 1 week, okay? Learned Counsel, Ms. Milosiniona,
Yes,
appearing for the respondent, submits that the leading counsel is indisposed and accordingly prays for listing the matter after 1 week. So, Learned Counsel, Mr. Such and Such, appears for the petitioner and has no objection, list after 1 week. Yes.
Obliged.
My pleasure, Lordship. Lordship, I beg to mention item number 8. On behalf of Kibapum, Lordship, can you list this matter after 1 week?
My lady, in this matter, the petitioner, the counsel of the petitioner is here, so let the matter be. For hearing is fixed for hearing. My lady, it's been quite some time.
It's a hearing matter.
Yes.
Why is adjournment being sought? And it's fixed. It's a fixed matter also.
Yes, Lordship. I have come down from Gauhati, Lordship. Petitioner, Lordship.
Let the matter come up, my lady.
Let the matter be taken up, Lordship.
Lordship, sub-emergency work coming.
You don't have the brief.
Lordship.
You get the brief, no, from for your colleague. Someone can appear. Let's see. Let it reach. Okay.
For motion, item number 1.
My Lord,
Oh, you filed again.
actually on 3rd, it was in the process of filing. So actually, my Lord,
So that's why it came up.
yes. So the IA number 8 of 2026, on the basis of the order passed by this Honorable Court on 2nd in 3rd, the order of the Honorable Supreme Court has been taken judicial note by this Honorable Court and the LCR has been called for. So by allowing this petition, it's nothing, no prejudice of course. Otherwise also, my petition has now become infractious because of the restoration by the Honorable Court.
Yes, it is already restored, so it's
Yes.
infractious now.
Lordship.
So any necessary order may be passed.
Learned Counsel, okay, Learned Counsel for the petitioner / applicant. Oh, you are for the appellant, isn't
Yes,
it?
I am for the appellant.
Mr. Pendangwapang for the appellant / applicant. Stop. By filing this present IA, the applicant has prayed for restoration of the connected criminal appeal 3 of 2021 on the ground that the Honorable Supreme Court by order dated 7/1/2026 had restored the said criminal appeal. Stop. A copy of, you have enclosed a copy, no?
Yes.
A copy of the
Annexure page 12. 12 to
copy of
16.
the order dated 7/1/2026 has been enclosed, has been annexed by the applicant. Stop. Para. Learned Counsel, Mr.
The Blue Marco, Lord.
Blue Marco
For respondent number
appears
3.
for respondent number 3 and Mr. Medovero for respondent number 1. Stop. Para. This court right order dated, which was the
Third.
3/2/2026 has already restored the criminal appeal 3 of 2021 on the basis of the order of the Honorable Supreme Court dated 7/1/2026, and therefore this this application has become infructuous and is accordingly disposed of as infructuous. And the main appeal is already fixed.
It is fixed after 4 weeks. Much obliged.
Disposed. Okay.
For motion, item number 2.
May I please, Your Lordship?
Yes.
Your Lordship, this IA is filed for implement of the new incumbent. That is Sri Muhammad Ali Shihab, who is the Commissioner and Secretary, Department of Power, my Lord.
Earlier, Commissioner and Secretary was the
She is no longer holding the post now. Who was arraigned as respondent number 9 in the contempt petition, Your Lordship.
she was 9, and now
Yes,
you
Your
want to
Lordship. Implead as
this
respondent
as
number
10.
13.
Oh, 13.
Yes, Your Lordship.
Okay. Earlier one was respondent. Heard learned counsel, Mr. Search for the applicant. The present application has been filed by the petitioner. Petitioner in COP 6 of 2010
2020.
or 2020, stating that during the pendency of the COP 6 of 2020, the respondent number 9 has been transferred out from the Department of Power, and Sri Muhammad Ali Shihab IS has taken over as the new Commissioner and Secretary in the Department of Power, Nagaland. So it is submitted that it has become necessary to implead the new incumbent, Sri Muhammad Ali Shihab IS, as respondent number 13 in the connected criminal contempt petition number 6 of 2020.
Civil contempt petition.
Civil original contempt petition number 6 of 2020. So, therefore, it is prayed that the impleadment may be allowed at this stage. So, the court has considered the facts and circumstances of the case, and the petition is therefore, the application is allowed, and the petitioner/applicant is directed to file an amended cause title impleading Sri Muhammad Ali Shihab IS as respondent number 13 in the civil origin contempt petition number 6 of 2020, and thereafter take steps for issuing notice on the newly impleted respondent by usual process, as well as inland speed post document within 3 working days. Then in the COP, you can say list the matter after 2 weeks.
Lordship.
After 2 weeks,
I oblige, my Lord.
and IA is disposed.
For orders, item number 5.
My pleasure, Your Lordship. Lordship, the service upon respondent number 2 has been returned unserved with the remark insufficient address. Lordship, I have taken the address from the certain documents such as FIR in the case. So now, if I may be allowed to take a fresh step through IO.
1 minute. You take steps through the concerned PS, no?
Lordship.
Heard learned counsel for the petitioner, Mr. M. Kongyak, no? Your name?
Manjong Konyak.
Manjung Kongyak. So learned PP appears for the state respondents. So the petitioner, the counsel for the petitioner submits that the correct address of respondent number 2 cannot be found, as the notice on respondent 2 has returned back unserved with the remark insufficient address in inverted commas, okay, insufficient address. So accordingly, it is prayed that he may be allowed to take steps through the jurisdictional police station, through the concerned police station. So accordingly, prayer is allowed the petitioner is allowed to take steps for service on the respondent number 2 through the concerned police station. So list after 3 weeks.
After 2 weeks, Lordship.
After
I'll
2
be
weeks.
finding my
Okay.
IOs.
Okay.
Lordship,
List after
if
2
the
weeks.
interim order may be allowed to
The
continue.
interim order passed earlier shall continue till the next day. Are you filing objection?
Lordship, in the IA, Lordship, to
Okay.
vacate the interim.
You file in the matter.
Obliged.
For orders, item number 6.
Yes.
Your Lordship, I'm appearing on behalf of Enangami, who is appearing for respondent number 1. I think the rest, I think the notice is not completed.
Notice not complete. Okay, 2 to 5 still awaited. Counsel for the petitioner. Ms.
On behalf of Sophie.
Oh, on behalf of,
Yes,
you are not in the matter?
No.
Okay, okay. Who appears on behalf of Mr. A. Sophie, counsel for the petitioner. Stop. Learned counsel, learned government advocate, Ms. Livika is present on behalf of Mr. N. Angami. And it is seen that from the office note that the notice on respondent number 2 to 5 is still awaited. So accordingly list the matter after 3 weeks awaiting service on the respondent 2 to 5.
For orders, item number 7.
Please, Your Lordship. Your Lordship, here I have an instruction to appear for respondent number 1.
1.
Yes, Your Lordship.
Learned counsel, Ms. Such appears for the petitioner. Stop. Learned counsel, Ms. Livika enters appearance for the respondent number 1. You have filed your Vaklatnama
No, Your Lordship.
and please for some time to file Vaklatnama and the affidavit in opposition. Stop. The return service reports on behalf of respondents. How many respondents are there?
respondents, Your
Number 2. Respondent number 2 is awaited. So list the matter after 3 weeks.
For hearing, item number 3.
Yes, who will appear? Government? PP?
May it please, Your Lordship. So this is for Lordship quashing of an FIR.
You have the brief.
It's pending since long and no stay is there also, Lordship. Investigation is, Lordship, continuing, Lordship. And a small issue, Lordship.
Okay.
Yes, Lordship, may kindly see small issue, Lordship.
And you are for the complainant?
Respond number 2, complainant, Lordship.
Number 2, my lady.
Lordship, may kindly see it's a quashing of an FIR, which is registered under section 406/418 IPC. And Lordship, may kindly see the FIR. At page number, Lordship, 16. It's a type copy.
1 minute, let me just see the last order. 812. Message. Okay, case diary is already here.
Case diary is there, Lordship. It is in the records.
Status report.
Objection of the respondent number 2 is there also,
Okay, yes.
Lordship. Lordship will find the FIR page number 16, the type copy. The original is also in English, but although a bit illegible, that's why type copy is there. Then Lordship may kindly see the date of FIR, 18/12/2024. Date of FIR 18/12/2024, and sections Lordship inserted 316(2) and 318(3) of BNS. And occurrence of office Lordship 28/8/2024 in column 3, point number 3.
Occurred on
28/8/2024. Date of occurrence Lordship.
So,
Then contents Lordship will find at page number 17. It's a long affair, but it's important Lordship. Then may I read that first I am skipping first paragraph as the details of the complainant. Then Lordship background information, accused details. So, accused is the petitioner here. Then Lordship, point B, agreement cum memorandum of understanding. This is important Lordship. On 28/8/2014, at the request of Mr. Jagdish Singh, accused in brevity, he is the petitioner, I entered into a written agreement cum memorandum of understanding, agreement in brevity, with accused for the execution of a contract work awarded to the accused under work order number so and so, dated 7/6/2014, work order in brevity. The agreement was witnessed by the friend of the accused, Mr. Wilson Kathar. The work involved constructing a 16.65 kilometer road from NEC Road near Upper Hiripi LP School to Dilai Sarihajan Road near St. Thomas English School in Bukazan district, Karbi Anglong, Assam. So the work was pertaining to Lordship, district Karbi Anglong, Assam. The total contract value was rupees 1,18,96,993. As per the agreement, I would execute the entire contract and at my own risk, cost and risk, while the accused would receive all payments in his bank account but would promptly release 98% of the payments to me while retaining 2% for him. The accused was obligated to facilitate smooth completion and timely payment for the work. Petitioner is the Lordship, original contract holder. Then he sublet the contract to the Lordship complainant.
Contract to the complainant.
The complainant. And he would Lordship, he was supposed to complete the entire work with his own money Lordship, and then he was supposed to get 98% of the payment. Then Lordship, facts of the case. I executed the entire work as per the specification and terms of the work order bearing all risk and cost. The contract was successfully completed, which was certified by the concerned department on 16/6/2022. The work was completed Lordship. Then the final payment of 84,95,529 was issued via check number so and so, which was deposited into the bank account HDFC Bank so and so of the accused. However, despite multiple assurances, the accused intentionally did not release the agreed upon payment. This is the Lordship in the actual allegation Lordship. He has taken all the entire amount and did not release any amount to the complainant, despite the Lordship there being an agreement. Then subsequent development. After several failed attempts to recover my rightful dues, I filed money suit number 2/2023, money suit in brevity, before the Civil Judge Senior Division Karbi Anglong Difu, Assam, and complaint case number so and so before the Judicial Magistrate First Class Dimapur, Nagaland, for the dishonoring of the check issued by the accused. Complaint case is still pending. However, money suit has become infructuous. This is important Lordship, has become infructuous. By order dated 18/11/2024, the Civil Court has taken the decision that it is without jurisdiction and further directed the matter to be filed before the competent court in Dibrugarh, Assam. So there was a clause that any dispute would be subject, any dispute pertaining to a said Lordship agreement would be subject to jurisdiction of the Dibrugarh court at Assam. So therefore, that Karbi Anglong court does not have the jurisdiction. So that court, learned court, has returned the plaint.
Otherwise, the work was done in Karbi
Karbi
Anglong
Anglong,
district.
yes. But because of the clause, the Dibrugarh court came into picture Lordship. And that's why the plaint was returned.
Otherwise, Karbi Anglong also had jurisdiction because the cause of action arose there.
But that was decided by the, yes. That was decided by the learned court that it has no jurisdiction, and the Dibrugarh court at Dibrugarh has the jurisdiction Lordship.
Okay.
And thereafter, till now, they have not filed any civil suit before the court at Dibrugarh. So this order has attained finality. And neither they have challenged the order. On 23/9/2024, the accused was in Dimapur. From here, Lordship, actual problem arises, Lordship. On 23/9/2024, the accused was in Dimapur. Therefore, I, along with the accused, accompanied by his associate, Mr. Sanjeev Bora, went to my father-in-law's residence at Chekia village to discuss the payment of the liability of the accused. Accordingly, we agreed and decided to prepare a declaration. In the subsequent deliberation, after necessary deduction, the total liability of the accused, inclusive of penal interest towards me since 27/3/2020, that is the date of check, date of issue of check, was rupees 1,48,04,336. This was decided as the final liability, including the penal interest, Lordship. However, at the request of the accused, agreed to further relax an amount of rupees 16,04,336 from the actual liability, thereby arriving at the current liability of rupees 1,32 lakh, acknowledging the fact that he had withdrawn the amount due to pay. Thus, before the notary at Difubara village, we executed a declaration bearing registration number so and so dated 23/9/2024, whereby the accused admitted his liability of rupees 1,32 lakh, acknowledging the fact that he had withdrawn the amount due to me but failed to pay. So that declaration was executed at Difupar on 23/9/2024, whereby the Lordship present petitioner admitted his liability of total Lordship 1,32 lakh. Through the said declaration, the accused agreed to pay by settling the mode of payment of his liability of rupees 1,32 lakh on 15/10/2024 with the assistance of his legal counsel. Acknowledging the execution of the declaration, the accused paid a token amount of rupees 20,000 via GPay on 23/9/2024. However, the accused has again deliberately failed to honor his declaration and liability. Despite the execution of the declaration, the accused has again failed to pay me the liability. Then, Lordship, submissions. By withholding the funds meant for me as per the agreement and declaration, the accused has committed criminal breach of trust. Second, Lordship, the accused dishonestly induced me to execute the work and deposit the payment into his account with no intention of fulfilling his obligation. After the deposit of the final amount into the account of the accused dishonestly misappropriated the amount for own use without paying me. The accused has fraudulently removed, withdrawn, and concealed the amount from his account, which was never his money, without paying me. So these are the submission. Then, Lordship, last paragraph, prayer. I humbly request your good office to kindly register the said FIR and book and try the accused under relevant provisions of law, and kindly recover the remaining amount of rupees 1,32 lakh still owed to me by the accused. So his prayer was to also to recover the amount through police, Lordship, through this FIR. Lordship, that is why this initial, Lordship, date of Lordship occurrence is very important. Page number 16. Date of occurrence 28/8/2024. And therefore, Lordship, 316(2) and 318(3) were inserted, initially registered. Thereafter, what happened, Lordship? The IO of the case filed a petition before the Learned Court of Lordship, JMFC, praying for altering the section to 406/418 IPC. Then Lordship may kindly see as page number 29, type copy. Annexure 2 to the Chief Judicial Magistrate, Dimapur Court, page 29, and the original at page number 30.
Yes.
Yes, that with reference to the subject cited above, I have the honor to state that at initial stage, the above referred case was registered under section 316(2), 318(3) BNS, but during the course of investigation, it was found that section 406/418 IPC is found to be more appropriate, since the said offence was committed prior to the implementation of the BNS. But in the FIR, date of occurrence is shown to be, Lordship, 28/8/2024, which was subsequent to coming into force of the BNS. But the IO said that 406/418 would be more appropriate because the offence was committed prior to coming into force of the BNS.
But according to you, offence occurred on 28/8.
28/8. That's subsequent final declaration, Lordship. And in the FIR also, occurrence of offence is stated to be 28/8/2024 by the police. Then, Lordship, may kindly see the order of the Learned Magistrate, page number 31. order dated 7/1/2025. Lordship has got it. Case record is put up on the strength of receiving an application from the IO praying for altering section to 406/418 IPC from section 316 to 318(3) BNS. Peruse the application as well as the case record, and on consideration prayer is allowed. Sections are altered to section 406/418 IPC as per the prayer of the IO. So as of now, Lordship, the FIR stands under section, Lordship, 406/418.
06 and 418.
418, Lordship. Then, Lordship, what happened? After significant development has, Lordship, occurred. After filing of this quashing petition, we have also filed one anticipatory bail application. Here, Lordship, what happened, Lordship, will find this maybe in the record. Lordship will see first order dated 11/2/2025. This is same petitioner, Lordship, pertaining to same case, Lordship, anticipatory bail. Then, Lordship, in this case, the Honorable Court was pleased to grant interim protection. However, Lordship may kindly see page number 2 of the order dated 11/2/2025. Page number 2, last para. Mr. E. Thiba form, the learned PP shall on the next day place the scanned copies of the case diary of Difubar PS case number so and so under section so and so. The learned PP shall also come with specific clarification as to whether the Difubar police station has the jurisdiction to register the present case against the petitioner when the dispute between the complainant and the petitioner relates to the execution of a contractual work at Karbi Anglong, Assam. So, Honorable Court was seeking, Lordship, the clarification pertaining to jurisdiction, Lordship, whether the Difubar police station has the jurisdiction to entertain the FIR when admittedly, Lordship, the contractual work pertains to, Lordship, Karbi Anglong, Assam. Then, Lordship, they can see the next order, 28/2/2025. By this order, this Honorable Court was pleased to make the interim bail absolute. And here, Lordship, the instruction is, Lordship, observed, pertaining to, Lordship, that jurisdiction point. That, Lordship, will find it, Lordship, page number, Lordship, 4. Page 3, para 4. Today, the learned PP, Mr. E. Thiba form produced scanned copy of the case diary, and upon perusal, it is seen that the accused petitioner had appeared before the IO Difubar police station on 19/2/2025, and his statement has been recorded by the IO. In the statement before the IO, the petitioner accused has admitted that he is yet to pay the amount of 1,32 lakh to the complainant due to financial problems. Regarding the jurisdiction, the learned PP has submitted that the last declaration signed between the petitioner accused and the complainant was signed and executed at Difubar on 23/9/2024, and hence the Difubar police station has the jurisdiction to register the present case. So, as because the Lordship, the last declaration was signed at Difubar and executed at Difubar on 23/9/2024, hence the Lordship, Difubar police station has the jurisdiction. But Lordship, what implies is that what happened prior to that execution, Lordship, that declaration, that Difubar police station does not have the jurisdiction to entertain whatever happened before, Lordship, that declaration. Whatever happened before that declaration happened pertaining to, Lordship, pertaining to Karbi Anglong, Lordship, that contractual work. And in that case, Lordship, the IO's, Lordship.
No, but out of the declaration also cause of action is there.
Lordship.
By,
yes, out of
by
the
signing
yes,
the declaration also.
Yes, cause of
action arose there also.
Yes, from the declaration. But Lordship, what happened in this, the stand of the IO becomes, Lordship, very important. In the prayer petition, Lordship may kindly see, I have just pointed out, Lordship, at page number, Lordship, 29, Lordship has gone through.
29, yes.
Yes, the IO has stated that the 406/418 IPC would be more appropriate because the offense was committed prior to implementation of BNS. So IO is saying that offense was committed prior to implementation of BNS. Whereas in the FIR, the date of occurrence is shown as 28/8/2024. That Lordship has already seen. 28/8/2024, occurrence of offense. Whereas, according to the instruction sent to learner PP, he has said that as because the declaration was executed at Difupar on 23/9/2024, the Difupar police station has the jurisdiction, Lordship. So his statement, his position is contradictory. IO is saying that offence was committed prior to implementation of BNS, hence 406/418 would be appropriate. And BNS came into force on Lordship 1st July 2024. July 2024, BNS came into force. And date of occurrence shown 28/8/2024. But in the instruction, he has said that because the agreement was executed at Difupar on 23/9/2024, therefore the Difupar police station has the jurisdiction, Lordship. Whereas in the Lordship prayer petition, he has said that the offence was committed before the BNS came into force.
Okay, BNS or IPC, not
Yes.
very fatal. Yes, that is
Yes,
not the very
that's why,
fatal.
Lordship, that alteration, Lordship, is contrary to record. If, Lordship, that date of occurrence is shown to be true.
BNS and IPC, that is not a very fatal error.
There is not a fatal error.
That is not fatal.
But the stand of the IO, Lordship, that is important. IO is saying that, Lordship, cause of action, Lordship, jurisdiction point, he has said that because the agreement was signed and registered executed at Difupar on 23/9/2024, therefore, Lordship, on a specific query made by this Honorable Court, he has said that the Difupar police station has the jurisdiction, Lordship. However, in the prayer petition, what he has said, that the offence was committed before coming into force.
Perhaps because the contract work was executed before BNS.
Yes, before BNS. That's why, Lordship, what I am submitting
So
is
the
that.
contract work is one cause of action.
Yes, and this
the
agreement.
declaration can be also another
Another,
cause of
Lordship.
action.
But what I am submitting is that if the law
But
with
it's all connected.
all connected
Out of the same
out of
issue.
yes maybe
Yes.
continue.
Yes,
But
continue.
whatever happened between the that agreement at Difupar is within the domain of, Lordship, Karbi Anglong. In that case, that is why this Honorable Court, while deciding the anticipatory bail, sought the specific clarification, Lordship, whether Difupar police station has the jurisdiction or not.
You have taken that ground here also in your petition.
That point is not there, but since a legal point, we can raise.
Okay.
And it is on record in the order, Lordship, also, that instruction of the stand of the IO. Because what Difupar police could have done easily, that they could have treated this FIR as a zero FIR, and send the same to the Karbi Anglong police, Lordship, for registering the same under proper section of law. Since the initial, Lordship, cause of action started in the year 2014 at Karbi Anglong. The moment.
Okay, that ground is noted. Then on merit.
Then on merit, Lordship, Lordship, in this case, what happened? The accused actually admitted the liability, the petitioner. So, Lordship will find that I have not annexed the, Lordship, that agreement. Lordship will find that the objection filed by my learned friend, Lordship, for respondent number 2, in the objection, Lordship.
Annexure A.
Yes, Lordship, Annexure A. That, Lordship, this agreement was executed on 23rd day of September 2024 at Chumokdima, Eastwell Dimapur, between the, Lordship, complainant and, Lordship, the accused. Here, Lordship, what happened? Everything is mentioned, Lordship. Then, Lordship, may kindly see page number 9. Now, this deed of agreement.
Yes.
Now, this deed of agreement witnessed that the first party hereby admits, first party, Lordship, is the, Lordship, first party is the, Lordship, petitioner, accused. Second party is the complainant. First party is Jagdish Singh, he is the petitioner. Second party is the complainant.
Second party is the complainant.
Second party in the, Lordship, page number 9. 2N in favor of Ahmed Hussain
Ahmed
Chaudhary.
Hussain Chaudhary.
Yes, he is the complainant, second party. Initially, they have narrated all the earlier facts. Now, what is important is page number 9, the operative portion of the. Now, this deed of agreement witnessed. Here, Lordship, they have para 9, Lordship will see, page number 10.
That the first party admits.
First party admits then declares that he owes to the second party a total amount of 87 lakh 31,529. So he has total amount, Lordship, he has admitted. Then Lordship, para 10, Lordship, that annual interest 18%, Lordship, that was calculated from 2020, that is date of issue of the check. Till the date of Lordship, that date. Then Lordship, 10 lakh he has already paid, para 11. That was deducted, Lordship. Then Lordship, para 12, here Lordship, interest was added. Therefore, inclusive of my interest liability, I owe the second party the total amount of rupees 1 crore 58 lakh 4,336. Then para 13, 10 lakh was again deducted, 1 crore 48 lakh 4,336. Then they have relaxed an amount of Lordship 16 lakh, para 17, as a goodwill gesture. Then Lordship, total liability comes to 1 crore 32 lakh. Page 11. Page 11, Lordship. Then the page para 18, that the first party and second party hereby agrees then declares that in respect of mode of payment of the aforementioned remaining liability, in accordance with the convenience of the first party, the same shall be finalized on 15/10/2024. Mode of payment, etc., Lordship. The first party shall come to Dimapur along with his legal counsel. The first party shall make part payment to the second party on 15/10/2024. The place of meeting shall be conveniently decided between the parties. So these are terms of the agreement. Then Lordship, before the police also, during his statement, he has admitted his liability to the extent of Lordship 1 crore 32 lakh. Then what I am submitting, Lordship, is that even we, Lordship, assume that the Difupara police station has the jurisdiction on the ground that this agreement was executed there. Then also, Lordship, violation will only mean that breach of contract, breach of terms of contract. Breach of terms of contract, for which the appropriate remedy lies before the civil court, Lordship. Because for earlier Lordship event, he has filed a civil suit for recovery of money, and that suit the court come to the conclusion that the court was without jurisdiction and adjourned the plain, Lordship.
And that appropriate court would be Dibrugarh.
Dibrugarh. That's why, because after that they have not filed any civil suit before Dibrugarh court, neither they have challenged that order of returning the plane before the higher forum. That's why that civil suit, final judgment of the civil suit has attained finality. Now that even for this violation of this alleged violation of this declaration, they may again seek recourse of civil remedy, civil court, for violation, for specific performance of contract, or for recovery of money. And it is not a case that he is denying, he has admitted. And more so, he has independently paid 20 lakh more, Lordship. That will be, Lordship, my learned friend will throw some light. 20 lakh he has paid in between, after registration of this FIR. He has paid 20 lakh more. I have the receipt, Lordship, through Lordship bank, Lordship RTGS transfer. So it is not that
after the FIR.
After the FIR. Then Lordship, it is not a case that he is denying, he is evading. So for that, Lordship, we cannot say
paid how much?
20 lakhs to the bank account of the complainant. The Lordship may kindly see this. One is two.
Okay, what else?
So after registration of this FIR, he has paid 20 lakhs more. So Lordship, what I am submitting that it is not a case that he did not have any intention to pay from the very beginning, Lordship.
Okay.
For an offense of Lordship cheating,
So
Lordship may
number one,
kindly
regarding jurisdiction, then number two, ingredient of 406, 418, not there.
not there because
Then
Lordship it is not
thirdly, you have also paid an amount.
Yes.
Certain amount after the FIR
After
was
the FIR is lodged.
filed.
Lordship, what happened is that for the offense of cheating, Lordship, the intention to deceive, to cheat, has to be from the very inception, very beginning. It cannot develop in between, Lordship. It is, the intention of cheating has to be there from the beginning, Lordship, of the transaction. And for Lordship, criminal breach of trust, that intention comes later on, Lordship. So, criminal breach of trust and cheating cannot go together. Both are distinct offenses. In cheating, the intention to cheat, deceive, has to be from the very beginning of the transaction. And for criminal breach of trust, after...
So you're saying that when the declaration was entered into, there was no intention of cheating.
There was no intention of cheating.
You had admitted.
Yes. I admitted my liability. I paid money after the registration of the FIR. So there was no intention of cheating. Had there been any intention, I would not have paid that amount. And also I would not have admitted the liability before police during the statement. So Lordship, and 406, Lordship, has to be that intention develops later on, Lordship. After the Lordship, the dominion, after the accused gets the dominion over the property, the intention develops later on. That now I have possessed the thing, I will not give it to the actual person, Lordship. I will misappropriate. That's why both are distinct offenses, Lordship. Why? Because intention in cheating is there since the beginning. And intention in criminal breach of trust develops later on. After the, Lordship, possession of the, or dominion.
For cheating, it has to be there at the very start, inception.
And for 406, criminal breach of trust, that intention develops later on after the accused gets the dominion of the property, custody of the property. He is required to give it to the actual person, but he misappropriates. So both the offenses cannot come together, Lordship.
Okay, then.
Then, Lordship, so that's why, Lordship, that jurisdiction point of IO is very clear that because this declaration is executed at Difupar, so we have the jurisdiction. Implying that whatever happened prior to the Lordship, that declaration, we do not have the jurisdiction to entertain. Actually, initial Lordship cause of action started in the year 2014, when these two parties entered into that agreement for construction of road. So what my humble submission is that the police at best could have treated the same as a zero FIR and sent the same to the Karbi Anglong police, Assam.
No, but when the agreement was initiated between the complainant and the petitioner, it was in good faith. There was no indication that he would not be paid the money.
No.
So cause of action did not arise at that time. It arose only when he refused to pay.
That is also, Lordship, in the year 2020, he has got the money. He has got the money from the Lordship concerned department. In his account, Lordship, in the account of the accused.
2020.
Yes. that is there in the FIR. Also, they have annexed some document also. 2020, he has, Lordship, received the money. 14, the agreement was executed. 22, the contract.
Contract was completed in
2022. Then Lordship, 84 lakh, that whatever that amount.
4 lakhs such and such.
Yes.
That is the final payment.
Final payment.
When was that received?
That was received, Lordship.
That means after 22 only.
After 22, that is in the Lordship, in the civil suit.
Construction was completed in the year 2017, my lady. And final payment bill was received on 23/3/2020.
Yes.
2020.
2020.
Yes, 2020, March 2020.
That is the date of Lordship receiving the money. It is there, Lordship, in the.
It's okay. Yes.
It is there.
Final payment 2020.
In 2020, Lordship, the contract was successfully completed, which was certified by the concerned department. And Lordship, then the Lordship, 2020, it is there somewhere. Yes, Lordship. Lordship, may kindly see page 19. It's a part of FIR, Lordship. Last paragraph, point number C. Accordingly, we agreed and decided to prepare a declaration in the subsequent year after necessary deduction. The total liability of the inclusive of penalties towards May since 2027/3/2020, which is the date of issue of check. It was decided, liability was decided to the extent of 1,48,4,336. So, Lordship, the payment was made on 27/3/2020, and that work was Lordship certified in 2022 by department. So, the department in Assam, authority in Assam, Lordship, has paid the money to the accused. So even if we assume that he has, Lordship, committed criminal breach of trust, so it was within Assam. Even if we assume for the sake of Lordship, think, Lordship, that he has Lordship misappropriated the money, but that 2020 onwards, so that can be said that 2020, when he has got received the money, he has misappropriated. That is a prior to the Lordship declaration was executed at Difupar. So that is within the jurisdiction of Assam, Lordship, Karbi Anglong. Then Lordship, that is the, and Lordship, they have, then Lordship may kindly see page number, Lordship, that is the judgment of the Lordship trial, civil court, Lordship, page number 33 of my petition, Lordship. That is a plain, Lordship. Page number 53. That is the final judgment, 18/11/2024, in money suit. Then that first paragraph is important. Both sides are represented. Today is fixed for judgment. However, while preparing the judgment of this case, this court has noticed that while entering into the agreement dated 28/8/2014, both sides had agreed that the courts at Dibrugarh district shall alone have the exclusive jurisdiction to try any of the disputes arising between the plaintiff and the defendant concerned in this agreement, irrespective of the fact that the cause of action arose at different places. Then, Lordship, last line, Lordship, last operative part, Lordship, may kindly see at page number, Lordship, 62. Second paragraph. Now coming back to the case in hand, the cause of action arises at Karbi Anglong district, and hence courts at Karbi Anglong district are also having the jurisdiction to try the case, as your Lordship has rightly pointed out earlier. However, since there is a clause of exclusive jurisdiction in the agreement cum memorandum of understanding dated 28/8/2014 to the effect that only the courts at Dibrugarh shall have the jurisdiction to try and the disputes between the parties, it implies that both the parties have consented and bounded themselves to resolve their disputes at Dibrugarh courts only. Therefore, Lordship, last paragraph, thus in light of the above decisions of the Honorable Supreme Court of India, I have arrived at the conclusion that although the cause of action arose at Karbi Anglong district, but the dispute should be tried at the courts at Dibrugarh. As such, let the plaintiff be returned to the plaintiff with a direction to file the same in the proper court. This order was not challenged by the complainant, the plaintiff therein, before the higher forum. So this order has, judgment has attained finality. Nor they have filed any money suit in the court at Dibrugarh. And pertaining to this last violation of this agreement at Difu Park, they have not sought any civil remedy for specific performance of contract or for recovery of money or for any damages.
What is this judgment you have enclosed? You have annexed, Annexure 7,
Lordship?
Annexure 7.
Oh, that is the defined, that is not important, Lordship, because I annexed, that is pertaining to Lordship. Earlier rupees, Lordship, this accused has issued 10 lakh rupees as check, Lordship, so check. And that we have challenged before this honorable court.
Oh, that is a different
That is
issue.
a different, Lordship. The party is also different, that Jitumuni Talukdar is the partner of this petitioner.
Okay.
That's different, Lordship, will not be any.
Anything else?
I have some judgment, Lordship. Yes, judgment. Lordship may kindly see the first judgment. Lordship may kindly see 2013-11 SCC 673. I have given there. Paramjit Batra, State of Uttarakhand and others. Paragraph 7. Paragraph 7, Lordship has got it. Internal page 7.
7. While exercising.
While exercising its jurisdiction under section 482 of the BNS, now 528, or of the Code, that is CRPC, the High Court has to be cautious. This power is to be used sparingly and only for the purpose of preventing abuse of the process of any court or otherwise to secure ends of justice. This is well settled, Lordship. Whether a complaint discloses a criminal offence or not depends upon the nature of facts alleged therein. Whether essential ingredients of criminal offence are present or not has to be judged by the High Court. A complaint disclosing civil transaction may also have a criminal texture. This is also well settled. But the High Court must see whether a dispute which is essentially of a civil nature is given a cloak of criminal offence. In such a situation, if a civil remedy is available and is in fact adopted, as has happened in this case, the High Court should not hesitate to quash criminal proceeding to prevent abuse of the process of court. And that facts of the case. In this case also, they have resorted to civil suit earlier. That was plaint was returned. So after that, Lordship, they have not filed any civil suit before the Dibrugarh Court. Neither they have challenged the judgment.
Okay.
So, Lordship, what happened is that, Lordship, as pointed out, Lordship, a complaint disclosing civil transaction may also have a criminal texture. But what is essentially is to be looked into whether a civil dispute which is essentially is of a civil nature is given a criminal color.
Yes.
Then, Lordship may kindly see one important visa holding, Lord, 2015. That visa holding, private limited and state of Kerala. 2015, 8 SCC, 293. Para 8 and 9, Lordship may kindly see. Internal page 9. Para 8, from the decision cited by the appellant, the settled proposition of law is that every breach of contract would not give rise to an offense of cheating. And only in those cases, breach of contract would amount to cheating where there was any deception played at the very inception. This is very important, Lordship. Only in those cases, breach of contract would amount to cheating where there was any deception played at the very inception. If the intention to cheat has developed later on, the same cannot amount to cheating. In other words, for the purpose of constituting an offense of cheating, the complainant is required to show that the accused had fraudulent or dishonest intention at the time of making promise or representation. Even in a case where allegations are made in regard to failure on the part of the accused to keep his promise. Even in the case where allegations are made in regard to failure on the part of the accused to keep his promise, in the absence of a culpable intention at the time of making initial promise being absent, no offense under section 420 of the IPC can be said to have been made out. Then para 9, it is true that a given set of facts Para 9, it is true that a given set of facts may make out a civil wrong as also a criminal offense. And only because a civil remedy may be available to the complainant, that itself cannot be a ground to quash a criminal proceeding. The real test is whether the allegation in the complaint disclosed the criminal offense of cheating or not. In the present case, there is nothing to show that at the very inception there was any intention on behalf of the accused person to cheat, which is a condition precedent for an offense under section 420 IPC. In our view, the complaint does not disclose any criminal offense at all. Criminal proceedings should not be encouraged when it is found to be malified or otherwise an abuse of the process of the court. Superior courts page 11.
Yes.
Superior courts, while exercising this power, should also strive to serve the ends of justice. In our opinion, in view of these facts, allowing the police investigation to continue would amount to an abuse of the process of the court, and the High Court committed an error in refusing to exercise the power under section 482 CRPC to quash the proceedings. So here, Lordship, what has been held that the intention has to be at the time of making the promise. It has to be there since the very inception.
Okay. Next.
Then, Lordship, another judgment, Lordship. I don't know. Naresh Kumar. That Naresh Kumar I have given, Lordship.
Yes, you have given two. Yeah.
3, 1 Naresh Kumar
No,
also.
you have given 2 copies of Naresh Kumar.
Oh yes, Naresh Kumar.
Just take this one.
Naresh Kumar, that citation
Para
is not
6
there.
and 7.
Para 6 and 7. Para 6 and Lordship. 6.
It's okay, don't read.
Yes.
Para 6 and 7.
These Paramjit Batra and Lordship, those are reiterated, Lordship.
Mere breach of
What I have already submitted.
yes. Then
6
in
and 7.
this Delhi Race Club,
Delhi Race Club. Then this is Lordship pertaining to Lordship 406 and 420.
here, para,
Para Lordship 10, 11, 12, 25, 26, 27, 28, 29, 30, and para 38. Then Lordship will kindly see para 38, that is important. If Lordship is that internal page 28. If it is the case of the complaint that a particular amount is due and payable to him, that he should have filed a civil suit for recovery of the amount against the appellants herein, but he could not have gone to the court of additional chief judicial magistrate by filing a complaint of cheating and criminal breach of trust. Then Lordship, that is important, final conclusion, para 41. Before we close this matter, we would like to say something as regards the casual approach of the courts below in cases like the one at hand. The IPC, Indian Penal Code, was the official criminal code in the Republic of India, inherited from the British India after independence. The IPC came into force in the subcontinent during the British rule in 1862. The IPC remained in force for almost a period of 162 years until it was repealed and replaced by the BNS in December 2023, which came into effect on 1st July 2024. It is indeed very sad to note that even after these many years, the courts have not been able to understand the fine distinction between criminal breach of trust and cheating. When dealing with a private complaint, the law enjoins upon the magistrate a duty to meticulously examine the contents of the complaint so as to determine whether the offence of cheating or criminal breach of trust, as the case may be, is made out from the averments made in the complaint. The magistrate must carefully apply its mind to ascertain whether the allegations asserted genuinely constitute these specific offences. In contrast, when a case arises from an FIR, this responsibility is of the police to thoroughly ascertain whether the allegations leveled by the informant indeed falls under the category of cheating or criminal breach of trust. Both cannot go together. Unfortunately, it has become a common practice for the police officers to routinely and mechanically proceed to register an FIR for both the offences, that is criminal breach of trust and cheating, on a mere allegation of some dishonesty or fraud without any proper application of mind. 43 para. It is high time that the police officers across the country are imparted proper training in law so as to understand the fine distinction between the offence of cheating vis-a-vis criminal breach of trust. Both offences are independent and distinct. The two offences cannot coexist simultaneously in the same set of facts. They are antithetical to each other. The two provisions under IPC, now BNS, are not twins, that they cannot survive without each other. So this is the observation of the Honorable Supreme Court, that criminal breach of trust and cheating cannot go together because both are distinct offences. Ingredients different, Lordship. And what I have submitted earlier before this Honorable Court, that intention in cheating is there from the beginning, but in criminal breach of trust it develops later on, Lordship.
The court has taken note of that.
Yes, Lordship. But this is my humble submission.
Okay, yes. Yes.
May I please, my lady? May I respectfully submit that no court whatsoever has passed any judgment stating that
Yes.
existence of section 420 and 406 should be a ground to quash FIR. The application filed by the petitioner is under 482,
Yes.
now 428.
520.
528. This Honorable has to consider the fact that whether FIR discloses alleged offense. With regard to jurisdiction, my lady, the provisions alleged against the petitioner is 406 and 418. 406, 418. Now the reason why the police station Dimapur endorsed those sections were because of Article 20 of the Constitution of India. May I kindly be allowed to read the relevant provision? Article 20, protection in respect of conviction for offences. Clause 1. No person shall be convicted of any offence except for violation of a law in force at the time of the commission of the act, charged as an offence, nor be subjected to a penalty greater than that which might have been inflicted under the law in force at the time of the commission of the offence. Now this is the law of the land, my lady. And the Honorable Gauhati High Court in 2024 has also passed a relevant judgment to this effect. So that area is also covered. Now with regard to jurisdiction again, the cause of action definitely arose when contract was signed in 2014, when final bill was issued in 2020, and payment.
Those were in Karbi Anglong?
Yes, Karbi Anglong. So the petitioner, the cause of action definitely arose in 2020 in Karbi Anglong when the deposit was made at the bank account of the petitioner. But the declaration executed by the petitioner himself in Chumukitima Dimapur validates that very jurisdiction, my lady. In that declaration, everything has been admitted. As stated by my learned friend, facts are not disputed in this matter.
No, facts are not disputed.
Yes, the only question
But
now.
jurisdiction of the Pupar PS would arise with regard to the declaration.
Yes, and then
only.
that in that declaration, every allegation set against the accused has been admitted. Now that gives jurisdiction to the Honorable Court in Dimapur as well as the police station, the investigating authority, my lady. Now, several citations has been placed by my learned friend, but my lady may kindly note that all those are with regard to section 420. The allegation level against the petitioner is 406 and 418.
is also cheating.
Yes, but 406, my lady.
For
Now,
legal.
Wait, let him complete.
yes, for the convenience of this honorable court, may I be allowed to submit the synopsis of the facts? My lady, the petitioner was awarded contract in 2014.
No, they are not disputing the facts.
No,
Facts,
yes,
they are
not
not
just,
disputing.
but it's very important that I place this judgment, sequence so that.
406 is punishment for criminal breach of trust.
Yes, I'll come to that, my lady.
Yes, then?
Agreement was, he approached me, the petitioner approached me, saying that he is in no capacity to complete that work. So, complete the work at my own expense, and then I'll be eligible for 98%, he'll be for 2%. Agreement was executed. Kindly come to, in my written objection, my lady, kindly come to page 18 of my written objection.
Yes.
Now, this agreement was executed at the instance of the petitioner himself. I'll take this honorable court to the relevant page, page 21, my lady. I'll just read out the relevant provision, which is which reads that the first party convenes that the second party as follows. I'll read A, my lady. May I?
Yes, please read.
The first party does hereby declare that as and when payments would be released, as and when, this is important, my lady, in his favor by the PWT department against the aforesaid work executed by the second party, the same shall be deposited in his account, and immediately upon clearance of payment, the same will be reimbursed to the second party. Now this clearly states that as soon as the money hits his account, the same will be delivered to the second party. Kindly come to next page again, my lady. Relevant is 2.1. The second party convenes with the first party as follows. 1, the second party does hereby declare that he will be entitled to receive 98% of the payments against the contract value. However, if the value, so 98%. Now, may I take this honorable court to page 26 of my written objection? Page 26. Now, this is the date where the final payment was made. And on the same date, the same amount was deposited in the account of the petitioner. Now, as per the agreement, he is obliged under obligation to reimburse that amount to the second party, which is me, my lady.
Yes, 2020, but why didn't you register the case in 2020?
Yes, I'll come to that, my lady. Now, since we have been acquaintances for quite some time, we were under constant communication, but the petitioner was not making the payment. So I approached the Tipu court. Now the Tipu court, my lady, I filed money suit before the Tipu court on 31/2023. The irony is, my lady, trial was completed in that. Issues were framed. The suit was contested. Issues were framed.
It was fixed for judgment.
Yes. Kindly allow
And the
me.
trial was done.
Yes. Kindly allow me to submit the issues framed for the. Now, second page, my lady, 5/8/2023, both parties are represented. Heard both the parties, and after a long going through the pleadings of both sides, issues are framed. Now, the next page is the issues, my lady, the last page. May I be allowed to read the issues? Issue number 1, whether there is any cause of action for the suit. Issue number 2, whether agreement cum memorandum of understanding that such and such was executed. Issue number 3, whether the plaintiff executed and completed the construction of such and such. Issue number 4, whether the defendant is liable to compensate/repay the amount invested by the plaintiff for the construction. Issue number 5, whether the plaintiff is entitled to any other reliefs as prayed for. Now, this suit was contested, issues was framed, but in this suit, the agreement where jurisdiction clause is
No, fine, now we are not concerned with this suit, because now it's over disposed, saying that you should file in Dibrugarh. So what stopped you from filing this money suit in Dibrugarh?
as this Honorable Court is very well aware, civil and criminal, their objects are different, my lady.
No, but in a criminal proceeding, you cannot get back your money.
Yes,
You-
our
you can
purpose is
never-
not
you
to
can-
get back to
you can
recover the
never
money.
get back your money in
Yes,
the
yes, our
criminal
purpose is
proceeding.
not to
Only
recover
through
the money, my
suit
lady.
you can get back your money. So in a criminal proceeding, we're only concerned with whether the ingredients are
Now,
there or not.
Yes, I'll
The
come to that,
ingredients
my
of the
lady.
consent
Kindly allow
section.
me to make my submission. The petitioner, I was the respondent number 2. I was before the Diffu Court for 659 days, my lady, and finally order was passed, which is also enclosed. And as per the order, as per that order, the plan was returned. Now, what does that mean? As per the judgment of the Honorable.
When it's returned means you have to file it before the appropriate
Yes, but
court.
that means de novo travel. Everything starts from the
de
scratch,
novo.
my lady. That is settled. That is settled law. This is paragraph 9. Paragraph 9 is Supreme Court judgment.
See, Learned Counsel, we are not on the money suit issue
Yes,
now.
no. I'm not trying to prove anything on that. So just that everything is back to square one. Just to address that. Everything is back to square one. Now, Your Honor may kindly notice that the final order in that suit was passed on 18/11/2024. Whereas declaration was signed on 23/9/2024,
Prior to the disposal of the money suit.
yes, declaration.
Money suit disposed on
Order by order dated 18/11/2024.
11/20.
After exhausting 659 days, my lady.
And
Declaration was made on, executed on 23/9/2024.
23,
9/2024.
2024, okay.
Now, FIR was filed based on this declaration. So may I be allowed to take this Honorable Court to page 7 of my written objection? Page 7 of
In this judgment, which para are you referring
para
to?
21. Para 21. I think it's
Oh, okay.
yes, para 21. De novo, written of plan means de novo trial. Everything has to start from scratch, my lady.
Yes, definitely, before the court having jurisdiction.
Yes.
It has
Now-
to start from scratch.
Just because the respondent, the aggrieved, the informant has not approached the civil suit for recovery, that should not be the problem of the accused, the petitioner. That is not his lookout.
No, definitely
Yes,
not.
now-
Definitely not. If there are criminal ingredients as well as
Yes.
civil ingredients, then both can also proceed together.
Now, may I kindly be allowed to read
Yes.
406 of IPC?
Because
406.
a case can have criminal color as well as civil ingredients.
Yes, that is settled, my lady.
So we
406
have to
is
see the
punishment
facts
for
of the
criminal
case.
breach of trust, so the definition is 405. My lady. May I read? 405, criminal breach of trust. Whoever, being in any manner entrusted with the property or with any dominion over property, dishonestly misappropriates or converts to his own use that property or dishonestly uses or disposes of that property in violation of any direction of law prescribing the mode in which such trust is to be discharged, or of any legal contract, express or implied, which he has made touching the discharge of such trust, or willfully suffers any other person so to do commits criminal breach of trust. Now, in this case, my lady, final bill was made on 23/3/2020.
2020.
So, by the agreement executed at the instance of the petitioner, he was supposed to reimburse that amount to respondent number 2 on that day itself, but which he did not, which means he was entrusted after the execution of the contract work, after the payment was received, that money was not his, that payment was not his, it was my money, which took place, the
But
deposition
he had
in his bank account.
converted it to his own use. That's what you're trying to say.
Yes. Now it's been Now it's been more than 5 years, madam. Your ladyship. It's been more than 5 years. Commissioner said that he has good intention about that money. The question to be considered before this honorable court, by this honorable court, under 482, is whether the allegation leveled against the accused are made out. My respectful submission is the ingredients, the charges under 406 is absolutely made out. And to substantiate my submission, may I kindly be allowed to submit some case laws, my lady? I have also xeroxed the entire judgment, but for the convenience, I've extracted the relevant.
Which one? This M. Krishnan.
Yes. Now, in this case, authority number 1, my lady, both civil and criminal was pending, case was initiated, so the accused filed FIR against the accused, ended up before the High Court saying that there is a civil matter on the same issue. So High Court took cognizance and then quashed the FIR. The complainant went to High Court, Supreme Court. The Honorable Appeals Court held that in same facts and circumstances, both civil and criminal were liable, and then impugned order was set aside. Now, the relevant paragraphs are 4, 5, 9, and 11. May I read, my lady?
1 minute. 4, 5,
Yes.
9, and 11.
Yeah. My lady, I have already given the I have one copy.
Isn't it this one? M. Krishnan?
Yes, that is the entire set, but I have
okay,
also
okay.
another.
Okay.
Yes. That will be convenient, my lady. In all cases of cheating and fraud, in the whole transaction, there is generally some element of civil nature. If mere pendency of a civil suit is made a ground for questioning the criminal proceedings, the unscrupulous litigants apprehending criminal action against them would be encouraged to frustrate the course of justice and law by filing suits. Such a course cannot be the mandate of law. Impugned order that concern would not be a bar to resort to criminal proceedings. I have not filed a FIR to recover my money. I know the consequences, the relief. Number 3, my lady, an act can result in both civil and criminal liability. Hence, merely because the act has civil liability, that does not mean that it cannot also have criminal liability. In this case, my lady, may I pause here kindly? The petitioner himself is admitting that this is my money, this is not his money. But he is refraining from delivering my property. Now the question is whether the ingredient of 406 is made out. In my respectful submission, yes, it is made out beyond any reasonable doubt. Because the moment that the money, the final payment was deposited in his account, it became a liability. He was under obligation. It was not his property. He is intentionally, willfully refraining, derailing the process, and in the process, I'm being victimized here. I've been before the trial court for almost 700 days. And at the end, what I received was the plane was returned, which means that I have to start the entire process again. That is why, my lady, since this Honorable Court is seized of the matter, I won't stretch it further. But my respectful submission is the accusation leveled against the petitioner, as admitted by himself, is made out. So this petition is liable to be, is not maintainable at all, devoid of any merit whatsoever, and liable to be dismissed with cause, my lady, with cause.
That initial agreement, with page,
In my written objection, my lady, page 18. And also, my lady, with regard to jurisdiction issues made by my learned friend, 9 grounds have been made in his petition, but no whisper of that jurisdiction. As this Honorable Court is well aware, settled principle that without being pleaded, no grounds can be considered. It has not been pleaded. Even so, the investigating authority is not devoid of jurisdiction. Declaration itself is clear, executed by the petitioner himself. It has been also notarized, duly notarized. He's admitting everything, and at the end of it, he's saying, come to different court. I've not filed this FIR to recover my money. But enough is enough, my lady. The petitioner should be held accountable.
okay. Done. Are you any
Lordship.
reply?
Short reply, Lordship.
Yes, that's all.
Yes, that'll be all, my lady.
Short reply. So regarding that judgments my learned friend had cited, that Lordship, civil and criminal liability can go together. There is no dispute. Well settled, Lordship. So I am not disputing that a set of facts cannot have both the liability, Lordship. It can have. Second thing is the Lordship, they are saying they have filed a suit in Lordship Karbi Anglong,
Yes.
knowing fully well that there is a clause for filing the Lordship any suit before the court at Dibrugarh,
Yes.
because they are party to the agreement, Lordship. So both parties are aware that suit is to be filed before the court at Dibrugarh. Despite that fact, they have filed the suit at Karbi Anglong. Then Lordship, trial was held, evidence was adduced. At the time of judgment, the learned court below came across that clause and held that the suit is not maintainable in view of the fact that plane is to be.
Irony in this, my lady, is
Lordship, may I complete, Lordship? He has submitted, Lordship. I am replying just, Lordship.
Let him
He has submitted, Lordship. So, Lordship, what prevented him from filing a suit before the court of Dibrugarh? The learned civil judge only came to the finding that that court is devoid of jurisdiction in view of the clause at the time of preparing judgment, and then the plane was returned. Plane was not dismissed. Plane was returned to be filed before the appropriate court at Dibrugarh. But neither they have filed before the court at Dibrugarh, nor they have challenged their judgment before the
As
higher
far as the civil proceedings are concerned,
Lordship.
That is not the concern of this court.
Lordship.
in this
Correct.
petition.
Correct.
Yes.
Correct.
It
So
is purely whether this
whether
court has to
ingredients,
see whether
yes,
the ingredients
yes,
are there or not.
yes,
That's all.
yes.
So I have heard
Yes.
everything
And
from
Lordship,
both sides.
thereafter,
So now let me examine.
Lordship, I will small
yes,
two issues.
yes.
Then Lordship, he has raised the plea that I have not taken the jurisdiction as a ground. But jurisdiction is purely a law point. It is not a factual thing.
That can
It
be
has
raised,
to be
that
pleaded,
can be
my lady.
raised at any time.
Yes, at any
It
time.
has to be pleaded,
And Lordship, in my petition also, I
especially
have
when grounds are reflected.
grounds are there. that when I,
Even if
Lordship,
that
may-
ground is to be considered,
May I
it
continue?
has no standing in
yes,
this
Lordship,
matter,
my
Declaration
friend has
itself
already
validates
completed.
Let him
everything.
complete.
Let me complete,
Let him
Lordship.
complete.
That jurisdiction is purely a law point, it can be raised, Lordship. It's not just a factual point. It is on purely on law. And I am emphasizing on the fact, on the basis that Lordship, this honorable court, while deciding the anticipatory bail, was Lordship,
Already I have, this is extra.
was insisting, was seeking, sought for that clarification, whether that Difuba police station has the jurisdiction or not. And those I have already submitted are the Lord stand of the IO, contradictory very. And Lordship, then also, even if Lordship, I have already in my petition, Lordship, crave leave of this honorable court to rely on some other grounds at the time of hearing of this application, Lordship. So jurisdiction point, Lordship can very well decide. And Lordship, there he is submitting that he has suffered a lot. Lordship, then he is submitting that, Lordship, my learned friend, that he has not filed this FIR for recovery of money. But Lordship can come to the, I have read out the FIR
You have
already.
already shown the FIR.
Yes, it is in the prayer that, Lordship, I humbly request your good self, good office to kindly register the said FIR and book and try the accused under relevant provisions of law and kindly recover the remaining amount of rupees 1 crore 32 lakh still owed to me by the accused. So prayer is that the police should recover the amount. That is important, Lordship, because this FIR is the crux.
No,
It is the foundation.
even if the FIR states that, how can the police recover the amount?
No.
They will never.
Police cannot.
They cannot,
Absolutely.
they cannot.
Police
Exactly, my
cannot.
lady.
Police cannot. But the learned friend is insisting that he has not filed this FIR for recovery. But the prayer says otherwise.
No, that is.
Yes.
That we can
And regarding the criminal breach of trust, it was prior to Lordship
in the
execution.
FIR, anything can be written.
Anything can be
But
written.
it depends on
Depends.
what the police takes out from there,
Depends,
what the
Lordship.
magistrate takes out
Depends.
from there. That's all.
And Lordship, that a criminal, that money was, I received the money prior to this agreement, Lordship, at Difupar. For that, the jurisdiction point will take care. That money was credited by the authorities of Assam. I have received the money. I am a resident of Assam, Lordship. How Difupar PS can examine, Lordship?
But you have not denied that it was executed in Tipupar, that
subsequent-
declaration,
That subsequent declaration, Lordship.
subsequent.
Subsequent declaration.
Which validates the
Yes.
jurisdiction, my lady.
Yes.
It's an extension.
And regarding 406 and 420, the cheating and criminal breach of trust cannot run together. I have already submitted judgment, Lordship, Honorable Supreme Court. If 406 is there, 420 or 418, cheating cannot come. If cheating is there, criminal breach of trust cannot come. Both
No,
cannot.
that finally, if the trial proceeds, then the magistrate will drop one.
But the Honorable
That's
Supreme Court
also
has,
not an issue.
but Honorable Supreme Court has also cautioned the police
Of course,
to apply mind whether which one will come.
But the practice is still going on.
Going on, but there is
it's
a wrong-
up to the magistrate.
Yes, that is a
But it
wrong
the-
practice,
It is
Lordship.
the court which can,
Yes, there is a wrong practice because
convict or acquit under
yes,
anyone.
that is if charge sheet is submitted, Lordship.
Later.
Yes, later. But what Honorable Supreme Court has said, caution the police to apply their mind to ascertain whether 406 will come or 420
So
will
in
come.
this case, proceedings are stayed, isn't it?
No.
Not stayed.
Investigation is still on
Oh,
because the
investigation is still
petitioner
on.
Still
himself
on.
has not been cooperating with the IO.
No, that is-
This Honorable
that
Court
is a
has
defined
resolved the
aspect.
matter. Even penalty was imposed.
That is for cost.
Cost was imposed.
Yes.
Because you didn't appear before the
And they have, for that, they have filed the cancellation of Lordship. The prosecution has filed the cancellation petition.
Now,
Lordship.
my lady, lastly,
That is a different aspect,
That
Lordship.
is
But
a different aspect.
yes, but what I am on is on this whether this FIR is required to be quashed or not. That I have submitted before your Lordship. And whether the anticipated bill is liable to be cancelled or not, that's a different issue. The state has the prosecution has filed an I for cancellation.
Okay.
That will take its own course, Lordship.
Okay.
Okay, Lordship.
Learned Counsel, your name?
Nurul Hassan.
Nurul Hassan for the petitioner, as well as Mr.
Kitoga Sumi for R2.
For R2. And do you have anything to say? No. And Learned PP, Mr. Vizumumi for the state respondents. I'll dictate in the chamber. Chamber
Lordship.
dispose.
Lordship is not keeping it as CAB.
No CAB. You just send this also. Let me see also.
Obliged, Lordship. Highly obliged.
So, Miss, your rule brings back to the
I'm coming, brother.
Buka pit ka sawal. Buka sawal sekian. Hello. खत्म हुई